So once again, good morning to you all and welcome to this webinar titled Government Suppliers, Tender and the Right to Information Law. My name is Sami Obeng and I lead the team here at Parliamentary Network Africa. And we would want to, on behalf of all of us, welcome you to this webinar. This webinar is part of Parliamentary Network Africa's Bill Symposium Series initiative. And of course, because of COVID-19 and its related matters, we have been able to connect with you in your respective offices, homes, or wherever it is that you're joining us at today to be able to give you some information on this introductory session to the right to information law as it applies to private institutions. And so I will take on the presentation from here while I charge you all to notify us in the chat box, use the chat box to provide us with any information on whether or not you're having any challenges. If you have any questions you would want to put across, please do well to send them in the chat box. My colleagues are collating those questions in the chat box, and at the appropriate time, we will be able to address them. This is to enable us keep this webinar within the 1 hour timelines which it has been planned for. Thank you so very, very much. On that note, having introduced you all and having introduced myself, Sami Obeng, team leader at Parliamentary Network Africa, I think that it's appropriate now for me to zoom straight into giving you some context, the context within which this webinar has been organized and why the organization PN Africa is doing this. So PN Africa, or Parliamentary Network Africa, is what we call a parliamentary monitoring civil society organization, a non-for-profit organization that focuses on executing programs and projects which are aimed at ensuring parliamentary openness across the continent of Africa. Now, we are based in Accra. Of course, we work across the continent, and as an organization, we focus very heavily on training, on how Parliament works and opportunities to engage with the legislature. Of course, as an organization that focuses heavily on how Parliament works and opportunities to engage with the legislature, we are also very, very mindful of laws that get passed by Parliament and how they affect, especially the private sector, especially for countries on a continent like ours, where private sector has been increasingly described as the engine of growth. PN Africa has 4 main thematic areas, and this is also to help put things in proper context with our discussions today. Our first scope of area of work focuses on parliamentary institution strengthening and support. In this area, we support African parliaments to develop and implement open parliament action plans. We also provide assessment of the work of parliaments across the continent and of members of parliament. We provide technical assistance to parliamentary committees and departments. And of course, we build capacity of members of parliament across the continent, including tracking legislation that are in parliament and engaging with various stakeholders on such legislation. Our second stream of work is in media and access to information. And this is important to this particular webinar because as an organization, we believe that parliamentary information belongs to everybody. The laws that get passed by Parliament must go down well with different stakeholders, irrespective of where you live, irrespective of where you work. And so we pursue the concept of democratization of parliamentary openness, parliamentary information, which in essence seeks to make sure that parliamentary information gets to everybody and anybody wherever you find yourself. Of course, our work stream also focuses on protecting the rights and freedoms of journalists who report from Parliament. We publish the parliamentary newspaper, which is a specialized publication that goes to members of Parliament across the Anglophone countries within the West African sub-region. And it is meant to take advocacy from civil society to them, as well as promote information that comes from Parliament to the general public. And of course, private sector is not left out in here because they are able to have opportunity on this platform to also market their goods and services which are targeted at members of Parliament. As an organization, we are conveners of Ghana's Media Coalition on Right to Information. And it's on this background that, having worked on the right to information law for so many years until it got passed in Parliament, we have put together this webinar to provide for you, private sector players, how you get involved in this whole right to information regime and how the regime affects your work as a private sector organization. Our third stream of work is in accountability, livelihoods, and inclusiveness. Here, we champion the need for members of parliament to account to their constituents. And of course, we support anti-corruption institutions on how they can promote anti-corruption measures, especially those ones that are targeted at parliament. We facilitate linkages between members of parliament and the things that make up for the livelihoods of their constituents. All of these are aimed at ensuring that Parliament's work in leaving no one behind. Finally, our final stream of operations or programs is in the area of convening and capacity building. And it's on this platform of convening and capacity building that we have actually convened this meeting this afternoon. We build capacity and support networks of parliamentary monitoring organizations, corporate institutions, other civil society organizations, all in the quest to make sure that the very things, the very laws that get passed in their country parliaments are known by them, are understood by them, and they can apply it in their respective works so that things can go on very fine for the legal regime that they operate in. We help to build capacity on how Parliament works and opportunities to engage. And our Bill Symposium Series, which is the platform on which this particular webinar is launched, seeks to engage with stakeholders on draft legislations or legislation that have immediately been passed, which affects them and their work. And so once again, let me welcome you all to this webinar. Let me quickly run you through some of the bills or laws that have been passed in Ghana, which this Bill Symposium Series platform has engaged with over the years. So in the past, we have engaged with the Ghana Deposits Protection Bill of 2016, the Securities Industry Bill of 2016, the Banks and Specialized Deposit Taking Institutions Bill of 2016, the Office of Special Prosecutor Bill of 2017, Standard for Automatic Exchange of Financial Accounts Information Bill of 2018, the Witness Protection Bill of 2018, as well as the Right to Information Bill on several platforms. And now that it has become law, we are engaging with you also on that. We have engaged on the Companies Act that has recently been passed by Parliament. We have engaged on the Chartered Institute of Human Resource Ghana, a bill that has been recently passed by Parliament, as well as the Chartered Institute of Marketing Ghana bill. There are some of the video footages of some of these past webinars online. And so for those of you who have joined, we will be, as part of the post-webinar emails that you get to receive from us, share with you. We will be sharing with you some of the video footages for you to go back to them and watch them should you want to engage with these old webinars that we have held. And of course, we'll be sharing the video footage for today. So just in case you either joined in late or you have challenges with your network connectivity, you can be rest assured that you will have the video footage for you to have a good watch at it at your most convenient time. And ultimately, to even watch it with your colleague staff so that they can all understand the very essence of the right to information law as it applies to your respective corporate institutions. So now let me quickly run you through why we are holding today's Bill Symposium Series. We understand that as an organization that tracks all bills in Parliament and works with parliaments across the continent, we recognize that the legislature's decision and the outcome of various parliaments across the continent and the world, for that matter, affects the operations and sustainabilities of institutions, especially private sector institutions. Why do we say this? A case in point is the Banks and Specialized Deposit Taking Institutions Law and the Securities Industries Law of 2016, which got passed in Ghana. Remember that these were the various laws that were used to embark on the financial sector cleanup, which has caused so many banks, specialized deposit taking institutions, microfinance organizations, savings and loans companies to collapse in less than 5 years of the coming into force of the law. This goes to strengthen the point that we make and our conviction that the laws that get passed by Parliament affects private sector, affect citizens, and for which reason there is a need for us to help you as private sector organizations keep an eye on either draft legislations that are before Parliament or recently passed laws, so that it can afford you enough time as an institution to put in place all the internal mechanisms and structures that you need as the new era comes into force with the law. And that is why we are doing this particular one also on the right to information law. So this webinar has been targeted at business associations, corporate Ghana, state-owned enterprises, professional bodies, non-governmental organizations, and of course, we have had several of you subscribing to this webinar. We see that a good number of you have already joined, while we expect others to also join along the line. We notice that those of you who have joined are either CEOs or managing directors of your respective organizations, chief operating officers, heads of your legal, HR or operations department, supply chain department, and what have you. And we wish to thank you very, very much for taking time to join us. Let me say that this is part of our series of online introductory sessions to bills or recently passed laws in Parliament. Once these introductory sessions get held, we are usually able to engage with private organizations that think that they would want to have some form of in-house arrangement or other forms of workshops that goes to provide more detail to the very subject matter that has been discussed. And we have those coming up. And so for the purposes of this RTI Bill Symposium, this introductory session will give you a very good idea of how the right to information law affects your respective organizations. And then subsequently, there will be a workshop that is seeking to provide you some follow-on support in creating the various things that needs to be created within your respective organizations to make sure that you are in compliance with the right to information law and you are not caught on the wrong side of the law. So now let me go straight into the right to information law, which is the very reason why we have met here this afternoon on Zoom. And for those who have just joined us, let me welcome you once again. Thank you for joining us from your homes, from your offices, from wherever it is that you're joining us from, especially for those of us who are working from home. This is a good way to connect with ourselves on subject matters that goes to the core of the work that we do. The Right to Information Act 2019, Act 989, is a law that has been passed in Parliament. And let me walk you through something we call the legislative footprints, which kind of introduces you to how this law became a law actually. So in 1999, civil society organizations drafted a bill on right to information. It was drafted by a civil society organization known as the Institute of Economic Affairs, IEA, here in Ghana. And between 2001 and 2010, the executive branch of government, the government engaged, consulted with various organizations, drafted various versions of the right to information law. Of course, on the 10th of February 2010, this particular bill was placed before the Parliament of Ghana for the first time. It took Parliament a little over 9 years to pass the law. So last year, on March 26, 2019, the right to information law got passed. Then on the 21st of May of the same year, 2019, His Excellency the President assented to the bill, for which reason it now became law. But remember that the law had a clause in there which says that it would not come into effect unless it has been, it will not come into effect unless it has been, unless the next financial year. And so 2020 now became a year in which the law came into force. So considering that we are in January of 2020, it goes without saying, considering that we are in July, of 2020, it goes without saying that the law has actually been in force for 7 months. And as private sector organizations, I'm sure you would be wondering, or in the course of this presentation, you would realize how a law that actually affects your work has been in force for 7 months. And maybe for many of you, you may not know about it. You may not even think that it affects your work. And so you may not have put in place any measures to be able to safeguard that. And that is what we are seeking to run you through today. Now, this is the background to what I have given is the background to how the law became a law. But now let's go into the issue of the object of the law, the right to information law. And it is important that we all look through this thing that I have projected closely. So Act 989, which is the Right to Information Act, is to provide for the implementation of the constitutional right to information held by a public institution. And I have highlighted and put the words public institution in red because I'll come back to something that is very, very interesting. So it's an act to provide for the implementation of constitutional right to information held by a public institution subject to the exemptions that are necessary and consistent, with the protection of public interest in a democratic society, to foster a culture of transparency and accountability in public affairs, and to provide for related matters. This is what is quoted in the law as what the lawyers will call the object of the act. But one will ask, if this is a law that is supposed to help provide transparency and accountability with regards to public affairs and with regards to public money, how does this kind of law, why should we care as private institutions upon the coming into force of this law? The reason private institutions must care is that the law defines the word public institutions, the very words that I have put in red above, as including any private institution or private organization that receives public resources or provides a public function. Now, this is significant because it is on the basis of this that we are holding this webinar with you today. Why is it significant? It is significant because if you are a private organization that does participate in government tenders, that receives money from the government to be able to supply goods and services, to be able to construct roads, to be able to provide engineering services or whatever form of services or goods or works that you provide for the government, because you are using government money to provide those services and to provide those works, you come under the regime of this right to information law in respect of that particular service you are providing for government, that particular public function that you are providing. And this is why this has become very, very necessary for us to engage with you as private sector players, so you will get to understand the full details of this law and how it applies to you in essence. Now, like I said, as government suppliers, tenders, those who tender for government contracts and what have you, this is important for you to know. And we notice that, of course, government since January 2020, when the law came into force, and even before that, has been very heavily focused on public institutions and how they can get ready for this new regime of the law. Of course, understandably so, because government will want to focus on its own so that government institutions do not get to be hit by the unexpected requests for information that may probably come up. But as private institutions, we as a civil society organization have taken it upon ourselves to provide you this information in here, and to also go about with some training workshops that will be taking place, especially in the month of August, which will seek to help you put in place your internal mechanisms as an organization to be able to stand in readiness for the new era of the right to information and how it applies to public institutions. On this note, let me continue to announce that if you have any questions, if you wish to make any comments, if the presentation is going too fast for you, if you want to give feedback to me as the facilitator, please do well to post them in the chat box. I will see them. My colleagues will also compile them, and we will be able to read your questions out at the appropriate time, and we will be able to engage with you at the appropriate time. So if any question comes to mind, you can note it down, put it in the chat box, and we'll answer them as appropriate. Now, having said this, now that we all know that the right to information law, by the definition of the term public institutions, affects you as private institutions that are providing public service or have received public funds to be able to provide public service, we need to know what then does the law say. And these are the contents to the law. So the Right to Information Act has 86 sections, which have been arranged under 12 broad areas as follows. There is the area of access to official information. It speaks about compilation and publication of manuals on information of any public institution. And here, please note that wherever the term public institution applies, it also applies to you, because the definition of public institutions include yours. Now, it talks about exempt information. There are provisions on procedures for which people can access information that are within your custody. There are sections that relate to amendments of personal records in the custody of your institution as a public institution or private organization rendering public service. There are sections relating to internal reviews and appeals. If people apply for information and they do not receive them, what opportunities are available to them according to the law to be able to seek internal review and appeals. There are bits relating to the establishment of a Right to Information Commission. I'm sure that those of you who may be following the news on this subject matter may have heard that there is a need for Right to Information Commission, and civil society has been speaking about it thoroughly. There is a bit about administrative and financial provisions. There is a bit about application for review by the Right to Information Commission, so that if the internal reviews fail, how somebody can actually apply to the Right to Information Commission. There are orders, decisions, and directives of the Commission and how it must be enforced, even enforcing them with private organizations like yours who fall under the ambit of the Right to Information law. Of course, there is a schedule that contains various oaths that needs to be, undertaken, of course, just like any law that actually establishes an institution, the oaths that needs to be undertaken by the organizations and the individuals that are employed under the law. So now let's go into the nitty-gritties of this law. Now that we have established that it's a law that actually affects you, it is a law that affects your company, and you fall under the ambit of the law, let's speak about access to information. So here, the law talks about the fact that a person has the right to information subject to the provisions of the Act 989, the Right to Information Act. And this is stipulated in Section 1 of the Act, which means that any Ghanaian and even non-Ghanaians alike, who are within the jurisdiction, who find themselves seeking or needing information from any public institution, i.e. a government organization or a private organization that is using public funds, has the right to information subject to what has been spelled out in this particular law. The law also speaks about public institutions and what their obligations are within the year 2020 and beyond. So as public institutions, and here I keep emphasizing that wherever public institutions are mentioned, it includes those of you who are having government contracts or using public money for to provide public services. You are under the ambit. The law says that in the year 2020, which is the first year that the law comes into force, within that particular year, within the first 12 months of 2020, and every 12 months that follows afterwards, you are to publish an up-to-date information in the form of a manual. This is stipulated in Section 3, 1, and 2. Section 3, subsections 1 and 2, where the content of the manual have been spelled out. And like I said, in the workshop that will follow, we will be able to have practical sessions with organizations on how they can help develop their manuals, what is supposed to be contained in the manuals, and how they can work towards meeting the timelines as stipulated by the law. Now again, the law requires institutions to generate, process, maintain, and preserve information which are accurate and authentic, and also to establish information units which will be headed by an information officer who shall facilitate access to information. So if your organization finds itself as one of the organizations that is catered for by the law, you are supposed to make sure that at all times you are generating, processing, maintaining, and preserving information in an accurate manner and very authentic manner, just in case anybody comes seeking those public information from your organization. Of course, you are also supposed to establish an information unit, which will be headed by an information officer who will facilitate such requests for information. Remember that application to access information shall be dealt with by this information officer, which I have labeled as IO, IO being the abbreviation for the word information officer, the words information officer. So sections 19 and 73 of the Right to Information Act speaks to it. But who is this information officer? Information officer is defined to include an officer within your organization as a private organization or as a public institution, or the officer that you have designated as the information officer to whom an application is made. So in some organizations, you may say that because of the sensitivity of this matter, the CEO of the organization is the information officer. So any request for information must come to the CEO or to the MD or to the head of legal or to whoever it is that has been designated. Once you have a designated information officer, the manual, as I have indicated above, will have to speak to those issues, will have to provide guidelines on who and who are these information officers, or who is this information officer, and how people can request for information, the processes, the contact details, and all of that. These things are spelled out in the law. And like I said, for those of you who already have government contracts running or fall within the ambit of this, I think that it would interest you to participate in the full day workshop that will follow sometime in August, which will help you put in place your internal mechanisms towards the RTI regime that has come into force. Now, let me go to the subject of exemptions. Subject of exemptions. So one may ask, does it mean that as a private organization that is using public funds, I must necessarily provide every information that is available to my company because I am using public funds, or because I come under the ambit of the Right to Information Act? The answer is no, because the law in sections 5 to 16 provides for what we call exemptions. So in every rule, there are exemptions, right? So the exemptions to the rule have been provided for in sections 5 to 6. And some of the exemptions, I will start first with the ones that applies to private sector. So there are exemptions, there are 12 areas of exemptions, broad areas of exemptions, some of which apply to the private sector, some of which do not really apply to the private sector. Information relating to law enforcement and public safety. Some information, if you hold information that relates to law enforcement and public safety, there are some exemptions that have been provided under the law for those. Information that affects the security of the state, there are some exemptions that have been provided for. Information on the economic and other interests that you hold as an organization, some exemptions have been provided there. Economic information of third parties. So whilst you are the ones dealing with government, if there are third parties that you deal with, their economic information, there are some provisions that have been made to protect those and to make them exempt from disclosure. Information relating to tax. So some tax information are also exempt under the law. Internal working information of these public institutions, including you as private institutions, so your internal workings, there are some exemptions that have been provided to it. Some privileged information that you own, you hold. So let's say you are a legal firm, the lawyer-client relationships, in privileged information that comes about as a result of lawyer-client relationship, as a result of doctor-patient relationship. These ones are also part of the sections that relate to exemptions. And of course, disclosures of issues that relates to personal matters. So let's say you are an organization, yes, you fall under the ambit of the law, but the request that is being made is prying into personal matters of the CEO or the MD. There are some provisions that have been made under the law that makes these ones exempt. Of course, these are the ones that relate primarily to the private sector so far as exemptions are concerned. But of course, there are other, public sector areas, and just for your information, I provide some of them. So information relating to the president or the vice president, information relating to cabinet, information affecting international relations, parliamentary privileges, fair trials, and contempt of court. These are all provisions that are under the Right to Information law, which are exempt. But there is a section 17 of the law, and that section is what in a Right to Information regime you describe as the harms test provisions. Harms test provisions. And for the avoidance of doubt, I want to run you through the harms test provisions just to be able to put into proper context the bit about exemptions. The harms test provision, section 17 of the law, states that despite a provision of this act on information that are exempt from disclosure, information is still not exempt from disclosure if the disclosure of that information reveals evidence of the following. 1, a contravention or failure to comply with the law. So you may have these exemptions, but if it is noticed that information that is being required under these areas of exemptions will reveal that you are contravening the law as an organization or you are not complying with the law, then the exemptions will be waived. Issues relating to an imminent or serious threat to public safety, public health, or morals, the prevention of disorder or crime, or the protection of the rights or freedoms of others. So if the information that you hold, albeit exempt, fall within the ambit of threats to public safety, public health issues, especially even in these COVID-19 times, the morals, prevention of a disorder or crime in our country, then you may be compelled to provide these information, even though they are exempt information. If the exempt information also, when provided, will be able to help avert the miscarriage of justice, then also you'll be compelled to provide those information. If there is an abuse of authority or the neglect in the performance of an official function, and it has been noticed, albeit exempt, the law also provides for this waiver of the exemptions, because these are the provisions under the harms test. And on any other matter of public interest, then you will be required to disclose this information, because in these cases, the law stipulates that the benefit of you disclosing this information, albeit exempt, outweighs the harm or the danger that the disclosure will cause to you as an organization under these exempt provisions, and you'll be expected to provide these provide for these information, although they fall under the exemptions. I'm sure that for those of you who have just joined us, just to still reiterate the points that as we go about this webinar, if you think about any question, if you have any question, you can post it in the chat box. We'll read it out. We'll try to address those within the 1 hour. Remember that this webinar is meant to last for an hour, so that we can all have some very good information for ourselves. Now, let me move to matters relating to procedure for access. So the law again provides for application to access information in section 18, where people can now, so remember that at this stage, you would have recognized yourself as a private institution, but you fall within the public institution's definition of the law because you are providing public function or because you are receiving public money. You have set up your information unit, you have your information officer, somebody requires information from you. So let me use a very practical example. I am an organization, I am the one constructing the road from town A to B. I have been given a government contract, several millions of dollars, and the citizens within the catchment area within which this road is being constructed requires some information. I am expected to have provided my information manual. I am expected to have had my information officers in place. I'm expected to have had my information unit where these people can apply for the information. When they come and apply for the information as stipulated in section 18, these requests can be through oral, through written, even through braille, through electronic forms. They can request, they can just send emails to be able to request, and these things must be stipulated clearly in your manuals. Other than that, you'll be in contravention of the law. And the law provides for how applications can be treated. So if there is a request that is provided, it's made of your organization, those ones that are exempt, those ones that are not exempt, how you should be able to deal with the exempt ones by replying back to the applicants that these ones are exempt, we cannot provide you. Those ones that are not exempt, you are enjoined by law to provide them. If the information that is being requested does not sit with your organization, but sit with another public institution, you are enjoined by law to provide a transfer of the application to that public institution. If there is a particular information that you already intend to publish within a stipulated period of time, so within the next 3 months already you are going to publish this information, then that is where the sections relating to deferred access comes in, where you are indicating to the applicants that, well, this information will be provided in its entirety within the next 3 months, so please, your access is being deferred towards the next 3 months, look forward to it, and you'll be able to receive those information. The sections relating to procedure for access also talks about the decisions on applications and timelines. The law gives a stringent 14 days timelines within which, when you receive an application for information, you must provide that information. And it gives some other timelines. You know, sometimes you even have just 48 hours to provide information because that information relates to liberties and personal liberties and safeties of individuals involved, their life and safety and liberties. All of these things are enshrined in the law. So The law provides for timelines for laws for information that is non-existent within the organization. So in the scenario that I used about a construction company that is constructing roads, how the non-existent information within your custody, you can communicate it back to the applicant. If you are also refusing to process or refusing to grant access to the individual that is requesting for that information, how you can communicate that and the timelines within which you can communicate that. The manner of access is also provided for. So the law states that people, so in this scenario that I use about the construction company, people can request that they want to inspect the work, they want to inspect the documents, they want a copy of it. If it's an audio, they want to listen to it. If it's a video, they want to view it. They want written transcripts. If it is just in sound or shorthand or coded information, they want written transcripts. People can request for it in written forms or any other forms, be it electronic, magnetic, whether optical, computer printouts, various computer storage devices, even through web portals. All of these provisions are made by the Right to Information Law, which is quite elaborate. And very soon, the ministry is expected to lay before Parliament a legislative instrument or an LI, which is supposed to even spell out how you as private institutions must comply with these things in detail. And that is why it is important that if you fall within the ambit of this law, you are putting in place your internal mechanism so that you don't find yourself on the wrong side of the law. Perhaps maybe for the past 7 months that the law has been in place, there has not been any individual or organization that has requested information from you as a public institution or a private institution that is providing public function, but you never know when this request for information may come up. And I'm sure that the recent directive by the High Court, even to the Electoral Commission, to provide information under this Right to Information Law is an example of how when people are not happy with the information you provide them or your lack of provision of information, they even have the right to go to court to compel you to provide them this information. The very reason why you must make sure that your internal processes are in place just in case this comes up. So if somebody applies for this information to your organization and you refuse the person access to information, the person has the right under sections 31 to 35 to seek for internal review. So here, remember that the person applied to the information officer. The information officer says, sorry, we cannot provide you with this information. The law requires that the person will now request again to the head of the institution. So now he will come to you, the CEO, or you, the MD of the organization, requesting that you change your decision, your organization change your decision of refusing him or her access to information. If this internal review process fails, the person has the right to apply to the High Court. And so I cited the Electoral Commission situation. Of course, the Electoral Commission is an independent body of state. It may not necessarily be equivalent to you as a private institution that is using public money, but the same rules actually applies. So when the particular member of parliament who applied for information from the Electoral Commission was told by the commission that, well, we cannot provide you this information, and the reason we can't provide it is that Parliament has not stipulated the fees that you must pay to access this information, the Honorable Member of Parliament went to court. The High Court has ruled that the Electoral Commission must provide all of that information to the Member of Parliament through the courts. And that is how the new regime of the right to information is going to be applied. And it will be applied also to you as private organizations that are providing public functions or receiving public funds for your work. Of course, there are instances also that somebody who has applied for information, has been rejected by your organization, has gone through the internal review process, been rejected, can also go to the Right to Information Commission without necessarily going to the courts. At the moment, Ghana does not have a Right to Information Commission yet, so it leaves the court as the basis or the place for people to seek information from your organization. What does this mean? It means that if we do not take care, then we will have an instance where people, because there is no RTI commission yet, and people start to apply for information from you because you are using public money or you are performing public function, they will now start to have to go to the High Court to compel you to provide these information. As private organizations, you know how these legal fees and having to be exposed to court arrangements can apply, for which reason you need to put in place your internal mechanism so you are not caught on the wrong side of the law. Because the law states that a person who is dissatisfied with a decision of a public institution, and I keep saying that wherever public institution is mentioned, it includes you as a private organization that is providing public function or receives public money. So if you are not satisfied with the decision, the applicant has the opportunity to seek, if you are dissatisfied with the decision of a public institution or a relevant private body, you may apply to the commission for a review of that particular decision. So talking about the RTI Commission, what is it? Like I said, it has not been established yet. It will be established soon. We hear from the Ministry of Information that it will be established soon. But this does not really apply to you now as private institutions. So I will not want to bore you with so much information about the RTI Commission for this webinar, but just to be able to highlight a few things, that the law actually establishes the commission, provides for the object of the commission, the independence of the commission, the powers, the functions of the commission, how the commission can promote the right to information, how the commission can be involved in research and law reforms. Monitoring powers of the commission are provided for in the law. Governing body of the commission, i.e. the board of the commission, are provided for in their tenure of office. The meetings, disclosure of interest, the committees that are established by the board, and the allowances of the board are all provided for in the law. And of course, limitations on the fact that if you are a member of the governing council body of the Right to Information Commission, you cannot hold any other office of profit. You know, those ones are related to those who are going into the RTI bits. But just for your information and for this educative exercise, we are highlighting a few of those. The law also provides for some administrative and financial provisions, such as appointments and functions of an executive secretary of the RTI Commission, secretary to the RTI Commission, board and other staff, appointment of other staff, the bank, the accounts, the audits, the annual reports, orders, decisions, and directives of the commission are all spelled out in the law. So what have I succeeded in doing? I have succeeded in running you through the summary of this new law, Right to Information Law. I have succeeded in pointing you to the fact that whereas the law is supposed to provide for accountability and responsiveness within the public space and trying to make citizens able to apply for information from public organizations, because public organizations are using their money, their taxpayers, their monies as taxpayers to provide public functions. The law also states that public institution includes you as private organizations who are using public money or are providing a public function. So I've explained these things about the law. I've explained the various sections of the law. I've given you summaries of how the law applies to private institutions with some examples of what will constitute a breach of the law. I've given you indications about the fact that the law actually indicates that if you fall within this category within this year 2020, you must have a manual on how people can access information. It must be published. You must have a right to information officer. You must have an information unit that must be providing these things and have somebody designated to provide this information. And so if you fall within this category, then I'm sure that as MD or CEO, you're running your mind through on how you can be able to achieve all of these things and the obligations that comes to you even in successive years. Now, like I rightly indicated, we are now going to move into the question and answer section. You have the Q&A box where you would have to put in your questions if you have any. You must state your name and your organization, please, if you put in your questions, so that I can be able to recognize you and address you as such and answer the questions that you may have for us. Remember that after this webinar, you will be receiving some emails. These emails from us will actually share with you the video of today's session, so that those of you who could not join in time, or those of you who would even want some of the other members of your staff to watch this in order for you to prepare yourselves adequately or to run your mind around this new regime, this will come to you. Of course, we'll share videos also. You are free to visit our YouTube page, Parliamentary Network Africa, to receive some of these videos of even past webinars that have been held, which relates to public institutions, private institutions, and your work as private sector, including the Chartered Institute of Marketing Law that has been passed, the Chartered Institute of Human Resource Management Law that has also been passed. Subsequently, like I said, in August, we'll be holding a workshop that will seek to help organizations that specifically requires assistance to be able to develop your internal mechanism. So that will be a hands-on workshop where we are bringing right to information experts and legal experts to be able to run you through these works that need to be done within your organization. And of course, we implore you to connect with us on social media if you have any questions. These are our social media accounts. Beyond today, you can always get onto our website, send us an email with any questions that you have. On this note, let me thank you all very, very much for your kind attention and for granting me audience, and to say that if you have any questions, this is the time within the next 5 minutes or so while we zoom towards 3 o'clock, try to answer those questions for you, and then we'll call it a day. Thank you very much. Any questions, please? Okay, so here I have been notified of some questions that came in through earlier questions that came in from participants through your email responses. There was a questioner who was seeking to find out that, does it mean that if I have not put in place my internal mechanisms yet as an organization that is already receiving public functions, I am contravening the law, and what remedies are there for me? Well, yes, if you have not put in place your internal mechanisms yet, you are not necessarily contravening the law, because the law gives the first year of operation of the law, which is the year 2020, as the period within which you must put in place your internal mechanisms, and after which now people can start applying. But of course, while you put in place the internal mechanisms, i.e. the manuals, people can still go ahead to apply for information from you without delay, and you are enjoined to provide those information to the people. But of course, around this time, your information officers, your information units, the internal mechanisms, all of them must be put in place. And we are always willing and able to provide you with detailed information on this, should you have the need for joining us in the workshop that will be taking place in August, which we'll be able to provide you information on. Still to remind you that those of you who are in the meeting, if you have any direct questions based on what you have heard, you can always post in the chat box or in the question and answer Q&A box, which are provided on your screens, to provide your questions so that we can be able to have the information, the questions that you have. Another questioner has actually asked, unfortunately, the questioner replied. So if you are sending your question, please send it to all so that everybody can probably see, or you can even send it to me privately. There is an opportunity for that. So I see that the questioner has sent me the information privately, wanting to request that. He says that I am a private organization that provides construction services, and we have government contracts currently running. Will there be an opportunity for us to learn more? No, with there being an opportunity for us to learn more through the workshop, when are we expected to have information on these workshops so that we can join in to have more detailed information with some other members of my staff? So like I said, you'll be receiving emails on these workshops, and when the time is due, you can join us, and we'll be able to learn how you can now do the hands-on work of developing the manuals, of setting up your information units, of making sure that you are in proper compliance with the law, and of ensuring that everything is working very, very fine for your organization. On that note, and considering the time, and considering that you are all busy people who have, okay, I see that there is, sorry, I was just going to, please, I did not join at the right time. Please, can you send the manual on the topic? Okay, so this is coming from Kedad. Kedad, we will send to all of you who registered for this webinar the video link so that you can be able to watch this entire webinar at your pleasure, at your leisure. And of course, you can even watch it with your colleague staff so that you can be able to, all materials necessary for this, once you have registered for this webinar, they will be shared with you, and you have the opportunity to relate with them. Thank you all very, very much. Now I have a few other questions in the chat box. In my company, I use bank money to execute government contract before payment. I'm not giving any mobilization. Do I still provide these information? Well, Mohammed, it is important to note that once you have a government contract, you are remember that the definition for public institution, according to the law, is that you are, it says that a public institution includes a private institution or a private organization that receives public resources or, and note this, provides a public function. So yes, you may be using bank loans to be able to provide it, but once the government will eventually pay you, and this is a public function that you are providing, you come under the ambit of the law. Thank you. Richmond also sends in a question, and he says that in the private sector, there can be victimization from a competitor who is not, there can be victimization from a competitor who is not happy with your company. So what happens if it is your competitor who is actually requesting for this information because they are not happy with your company? Fortunately, the law provides for instances where you are not required to provide this information because you notice that the person who is requesting the information is requesting it for vexatious, frivolous reasons, which you can be able to justify. And so these are also provided for in the law. And I'm sure that within the workshop that we are going to be having, these very detailed ones will also be provided to you so that you can see how you can ready yourself as an organization for this new era of the right to information law. On that note, now that I notice that there are no more questions in the chat box, let me thank you all very, very much for joining us here at Parliamentary Network Africa for this webinar. Please note that before the end of the week, you'll receive an email from us, which will require you to fill some evaluations so that we can be able to understand how today went. We'll provide you with a video and provide you with other information that will be necessary for you. When you receive these, do not hesitate to get back to us via email. I will be more than happy and willing to engage with you. And please take note that you can share this video with your colleagues. You can always get yourself in readiness for the month of August, where we'll have a full day hands-on workshop on preparing yourself for the right to information regime, and we'll be inviting you to join us. Thank you all very, very much, and enjoy the rest of your day. Goodbye.